Stage 6, expert-guided discovery. After your lawsuit is filed, your case enters a phase where both sides gather information and ask each other questions. This process is called discovery, which means court-supervised information exchange, where both sides investigate each other's claims. Think of it like both sides showing their cards before trial. It's where we use our experience to guide you and protect you from making mistakes that could hurt your case. Let me walk you through what happens in discovery and how we prepare you for each step. Discovery typically happens in a specific order. First, the defense attorney will send written questions called interrogatories that you must answer under oath, meaning that you're swearing that your answers are truthful and there are legal consequences for providing false testimony. We will sit down with you and help you prepare clear, accurate answers to every question. Next, they'll send document requests asking for documents, things like your medical records, employment files, and photos. We handle gathering and organizing all of this for you. Then comes the most important part. Your deposition, a recorded interview where the defense lawyer asks you questions under oath about the accident, your injuries, and how they've affected your life. A court reporter will be there creating a permanent transcript of everything you say. Now here's what insurance companies are hoping happens during your deposition. They're hoping you'll say something inconsistent with your medical records. They're hoping you'll downplay your injuries to seem tough. They're hoping that you'll get frustrated or angry and say something that they can use against you at trial. Defense lawyers are trained to ask questions in ways that trip people up, and they're counting on you not being prepared. That's their strategy, and it works on people who go through discovery unprepared. Here's how we protect you from those tactics. We will meet with you as much as necessary before your deposition to practice the types of questions you'll be asked and talk about how to answer them carefully. We'll be sitting right next to you during the deposition itself, and we can stop the defense lawyer if they ask improper questions. While you need to be honest and careful because your answers become permanent evidence, you won't be facing the defense lawyers alone. We will prepare you so thoroughly that you'll walk in confident and walk out without giving them any ammunition to use against you. After your deposition, we'll get our turn. We'll depose the defendant and the witnesses who saw what happened. Then we'll depose the experts on both sides, doctors, accident investigators, and others. This entire process can take several months to a year, and it requires patience. But here's why it matters. This is how we learn what arguments the defense will make, find the weaknesses in their story, and gather the evidence we need to win at trial or to force a fair settlement. And here's what we see happen time and time again. Once the defense realizes how strong your case is, how well prepared you are, and how their own witnesses hurt their defense, insurance companies often become much more willing to negotiate fairly. Discovery can expose their weaknesses just as much as it can test your case. At RSH Legal, we have guided thousands of clients through discovery. We know exactly what defense lawyers will ask, exactly what traps they're setting, and exactly how to prepare so you don't fall into them. If you are facing depositions and written questions from defense lawyers, don't go in unprepared. Call RSH Legal today. Our experienced trial lawyers will prepare you for every question and protect you from tactics insurance companies use to reduce your settlement.